15 people indicted in the recent bribery expose within the judiciary by Anas Arimaya Anas have been identified as officers from the police, prison service and the Attorney General's Department. A statement issued by the Judicial Service says their names and photographs have been forwarded to these institutions for further action. Also, the Judicial Service has assigned a Justice of the Court of Appeal to handle all cases filed so far in connection with the bribery scandal. Meanwhile, despite the numerous injunctions and contempt cases filed against Tiger Eye, its CEO, and some key media institutions and personalities, the screening of Ghana in the Eyes of God is still coming off on 22nd and 23rd September. So what are the implications of all these court cases, and what happens to the police, prisons and the Attorney General's Department staff indicted in the scandal? My name is Aisha Ibrahim and this is today's big story. Management of the Judicial Service, with the aid of audio-visuals provided by Anas and his Tiger Eye team, has been able to identify 80 other judicial staff caught up in the bribery scandal. In a statement issued today, the service detailed steps being taken so far to establish whether or not there is a prima facie case against the High Court judges alleged to have misconducted themselves in the bribery scandal, revealed by Tiger Eye PI. Joy News Kwacha Fred Nyama will join us shortly in the studio to take us through some of the key points in that statement. So Kwacha Fred Nyama will join us shortly and we'll get to know the details of this statement issued by the Judicial Service. Kwacha Frenyama is now in the studio with me. Hello, Kwacha Frenyama. You have been in court and you've been following this issue quickly, and you've also read the statement. Let's look at the key elements in this statement.
This statement is signed by the Judicial Secretary, Alex Pokwe-Champo, and starts by saying that the Chief Justice is in the process of establishing whether there's a prima facie case against the High Court judges alleged to have misconducted themselves in the bribery scandal revealed by Tiger Eye PI. And very instructive point here that out of the 12 judges here we're talking about who are in active service, 8 have up to Tuesday, September 22, 2015 to furnish the Chief Justice with their responses. Now, the statement then goes ahead to list a number of key points here in respect to rather key initiatives that or steps that the Chief Justice is taking in tackling this particular matter. Number one, that a justice of the Court of Appeal sitting as an additional High Court judge has been assigned to handle all the cases filed so far in respect of the bribery scandal. Of course, we know that a number of the judges, particularly the High Court judges, and in fact 14 of the lower court judges have filed various writs in court seeking to place an interlocutory injunction on the viewing, the committee sittings and all that.
Sure.
What this statement is saying is that an appeal court judge has been tasked to sit on this particular matter. And of course, they've also provided they've provided, you know, space for those who may want to appeal the process. That avenue exists. Is in the second point made here in the statement says that an appellate panel has also been constituted to hear all appeals and applications that may arise from the decisions of the High Court. Now, in respect of the court staff who are alleged to have been involved in the bribery and corruption management with the aid of the available audiovisuals and still pictures provided by Tiger Eye PI, I've been able to identify 80 of them. Now, as the disciplinary authority for junior staff, the Judicial Secretary has constituted 2 committees to investigate the various acts of misconduct. Now, the next point here, very instructive, pretty interesting, that 15 people in the list submitted to the Judicial Council. So far, what we've heard are names and the list, essentially that contained persons within the judicial service, court clerks and judges. But what the statement again is saying is that, as I mentioned earlier, 15 people in the list submitted that are now submitted to the Judicial Council are staff, are not staff of the judicial service. In fact, the report indicates that they are staff of the police service, the prison service, and the Attorney General's department. Of course, these are all these persons are all part of the chain when you talk about how the judicial process is carried out, and their names, according to Justice Alex Poku-Echampong, and photographs are being forwarded to the relevant institutions for necessary action. That's talking about the police service, the prison service, and the Attorney General's department.
You have been monitoring everything today, sitting today. So what could you tell us what really transpired and possibly some of the notable observations you made? Yeah,
Anas was expected to be cross-examined today by the lawyers for these judges who've been implicated. I'm talking about the lower court judges, the circuit court judges, and the magistrates. But today's sitting could not come off at all. And I'm sure you remember that already 14 of them have filed a case in court seeking to stop the committee from sitting at all. And the committee is saying that based on this application for interlocutory injunction on their sittings, they wait for the court to sit, the High Court to sit on Tuesday, that's the 22nd. Then they will sit on the 25th, that's next week, Friday. And based on the outcome of that particular meeting, they will know the way forward. So the next sitting has been scheduled for 25th September.
Which is Friday.
Friday, yeah.
Many thanks to you, Afre. On Friday, we're sure you're going to monitor issues and come back with some stories. And Charles Bentum, lawyer for 14 of the Circuit Court judges implicated in the Bribery scandal, has also reacted to the statement issued by the Judicial Service. Let's watch him.
We were informed by the panel hearing this inquiry that they have had notice of the injunction that we filed, which is scheduled to be heard on the 22nd of September, that is next week, Tuesday. It is their view that by reason of the pendency of that application for injunction, they have to halt whatever they were doing and allow that process to be gone into, that is the hearing of the application and the outcome determined one way or the other before they proceed. So they have adjourned this hearing to 25th of September 2015.
What does this mean to you? You were all along pushing that this sitting should not come off in the first place. What does the committee's decision mean to you?
Well, for us, the larger picture is that that committee should not sit, and because we have issues with its empaneling or composition. But for now, we are looking at the application for injunction, and we are happy that the panel have decided that they will allow that application to be heard and determined one way or the other. So we think that it is in the right direction that they've taken that decision.
And your clients, they were in court today?
Yes, they were, yes.
How do they feel about this?
Well,
do you feel it's delaying the entire process?
No, they don't feel it's delaying the process. They are happy that the due process of the law is being followed by both parties in this matter. That we are asking that we are expecting that the application for injunction will be taken, and that they will not, sidestep the application and proceed with the hearing today. And today they come and hear that, they are not going to continue today. They want to wait and let the injunction be heard. I think they are okay with that.
This is today's big story. Now, my Joy Online editor, Malik Dabo, has been following this matter since it came up. Now, so we have him in the studio right now. Hello, Malik. Many thanks for your time on today's big story. So give us a background of all the cases that have come up, since these judges were indicted.
Okay, so we know that there were basically two groups. We have the lower court judges made up of circuit court judges and then magistrates. Those were 22 of them. And then we had 12 high court judges. The 12 high court judges that were captured on this video allegedly taking bribes. 2 of them are on retirement, so there are 10 of them left. Now, the law requires that if you have complaints against a high court judge, you send a petition to the president stating the grounds upon which you are filing a complaint.
Exactly.
In the case of the lower court judges, i.e. the circuit court judges and the magistrates, you petition the chief justice. So what Anas did when he gathered this evidence was to petition the president in the case of the high court judges and petition the chief justice in the case of the lower court judges. Now, when the president gets the petition, the law requires him to forward that petition in the case of the high court judges to the chief justice, for the chief justice to look into the matter and establish whether there is a prima facie case against the person against whom a complaint has been made.
Right.
So in respect of the 12 high court judges, the president forwarded the petition filed by Anas and his Tiger IPI to the chief justice.
Right.
The chief justice is in the process of establishing that prima facie case against them. So what the chief justice did was to write to all the judges involved, called them, sent them letters, allowed them to see the video, and then gave them time to respond to the contents of the video.
Exactly.
In the case of the lower court judges, the chief justice established a 5-member disciplinary committee to institute disciplinary action against them. Now, let's look at the high court judges. When the high court judges were invited to respond to the issues contained in the video, some of them indicated that they were going to challenge the circumstances under which disciplinary impeachment proceedings were instituted against them. One of them was Justice Paul Utaderi. He was the first to file a case that was on Monday. He brought a writ at the High Court asking for essentially 17 declarations. One of them was that the video which formed the subject of this case was collected illegally and unlawfully. He further argued that the collection or the recording of private conversations with him was in violation of his right to privacy, that his privacy was violated in the recording, that the law required that if you wanted to record him, you ought to seek his permission first, and this was not done by the investigators, and therefore, to the extent that the collection of the video was unlawful, that video could not be used as that he was going to screen the evidence that he collected.
Before we go to the screening, I quite remember that in that rate, he also, he sued Suleimana Barima of the Media Foundation.
That's his third suit. He has brought 3 suits this week alone. He brought one on Monday,
what is he seeking?
One on Wednesday,
with the
and then one on Friday today.
On
Friday today, because he had filed the 2 suits already, and I was laying the background. The first suits were just saying that the evidence was collected unlawfully, it was against my fundamental human rights, and it should not be screened. Now, on Wednesday, when he brought the second writ, he said that, look, the International Conference Center, managers of the International Conference Center should not allow the premises to be used as venue to screen the video. His argument was the law requires that if there is a case against a high court judge, that case should be heard in camera. He argues that to the extent that this law requires this, and this is in the Constitution in Article 1468 of the Constitution, he said the evidence that is supposed to be used at the hearing, which the Constitution says should be done in camera, that evidence cannot be put in the public domain. Therefore, the screening should not be allowed. If the screening were to be allowed, it would prejudice people's minds against him. His right to fair hearing will be taken away from him. To that extent, the screening should not be done. In the third writ, he's saying that in spite of these 2 cases that he has filed at the High Court, seeking to injunct the screening of the video, the Crusading Guide and some other media houses have gone ahead to continue to screen them. And the Media Foundation Executive Director, Suleimana Barima, is one of the persons who have made comments after he has filed this case. And he's citing the law. The law says that if you have a case and you take the matter to court, the matter in issue should not be touched. If he's seeking an injunction against the screening of a video, that video cannot be screened. You cannot be seen taking steps that will lead to the screening of a video when he has filed a case in court against same.
Very interesting. I'll have you hold Malik and get onto the phone lines now, because former president of the Ghana Bar Association, Frank Davis, is joining us. Good evening and welcome on today's big story.
Thank you and good evening to you.
Let's take a critical look at the statement from the Judicial Service. Key issue is the assignment of a circuit court judge sitting as an additional high court judge to handle...
Assignment of what?
An additional circuit court judge sitting as an additional high court judge to handle...
No, he's a court of appeal judge sitting as an additional high court judge. It's a court of appeal judge.
It's a court of appeals judge. Thanks for the correction.
Sitting as an additional high court judge, yes.
But they are supposed to handle all the cases filed so far on the bribery scandal. So what benefits accrue to this step? Does it necessarily speed up the adjudication on the matter?
Anyway, good evening to your esteemed listeners. The Chief Justice, in circumstances like this, where there's a matter of strict urgency that these matters be heard expeditiously, you have to take this against the backdrop that we are only to let the people who are running the broadcast know the implications of the process that they served on them. Okay. That's all I can say. It has to do with service. If they have been served, and if the other parties, you don't even need to be a party to the application.
Okay.
If the parent defendant has been served, it is obligatory on that parent defendant to let those who are going to screen there know that there's an application for injunction. Of course, if they are advertising the program, that necessarily doesn't mean from has been shown. But in all these instances, any act or conduct which tends to bring the administration of justice into disrespect or dispute is contemptuous of the court. So,
Mr. Davis, it's still obvious that these cases, the several cases, would have an impact on the main case. What impact can it have?
Which other several cases are you talking about?
The cases that have been cited by the judges against the main case being handled by the Chief Justice.
I don't know which other case you're talking about, which has been cited by which judges. I know of only one High Court judge who was going to court as of now. It is Justice Peter Derry. He is the only one who has brought an application before the court. He is the only one who has constituted an action in court. I don't know of any other judge, so maybe unless you educate me. Apart from Justice Derry,
so let's look at the event.
There are some people who have also brought an application here in the Supreme Court, some of the lower court judges. But those are in respect of different reliefs. So I don't want to box those ones with what you have asking me.
Indeed, we know that Habib Logo and also filed a case and all of that. But let's go into the event where there's a prima facie established against each judge indicted in the scandal. What happens next?
Well, if a prima facie case is made out with the High Court judges, of course, the impeachment proceedings will have to be done in camera. Okay?
Right.
With the judges of the lower bench, the magistrate court, and the circuit court, the disciplinary committee of the Judicial Council would try those cases. So that's the distinction.
And so if no prima facie case is established, what else would happen?
I mean, that's the end of the matter. The purpose of the investigations that are being conducted now is for the investigative body to come to a conclusion that from what we have seen and from what we have heard from you, a case has been made against you. So if there is no prima facie case, that's the end of the matter. It means the person being accused or the allegations leveled against the person has not been proven. So that ends the matter there. You realize that for some of the lower court judges, there were cases of mistaken identity, and I guess 3 of them were left off the hook. I mean, that is what it means. The prima facie case has not been established because if there is a photo video of a scene and you say that Frank Davis is going to take bribe, and the video is shown and it clearly depicts that it's not Frank Davis who's on the video, what case can you make against him? You can't.
Absolutely, so no case. Many thanks to you, Frank Davis. Really appreciate your time on today's big story. Let's return to the studio and continue with Malik. You're talking about Justice Derry, and Justice Derry looks so determined to seek justice.
Yes.
I mean, is this not surprising?
Well, it's not surprising because there's the fundamental law is that everyone is presumed innocent until proven guilty.
Right.
There's a presumption of innocence in any matter that appears before a court of law. So the fact that he's seen on a video, or he's alleged to have been seen on a video collecting money, is not of an in itself prima facie evidence that he's engaged in some impropriety. And I was explaining to somebody the other day, the law is funny. If you put your laptop here and I picked that laptop and you saw me picking the laptop, and because there was no one else here, I picked the laptop and the cameras caught me picking the laptop, you would instantly say that I'm a thief, I have stolen the laptop. But the definition of theft by the law says that appropriation of property belonging to another person with the intention of permanently depriving the person of its use is theft. So I may have appropriated your laptop, fine, but do I have an intention to permanently deprive you of the use of that laptop? If you cannot prove that I have this intention, then you cannot make out the allegation of theft. So for the ordinary citizen, if you see me picking the laptop, you can say I have stolen it.
Right.
But the law defines theft. If you cannot prove that I picked the laptop and that my intention was to permanently deprive you of its use and that laptop belongs to you, other than
then
me,
there's no case.
Then there is no case.
Let's get on to the phone lines, Malik. I'll have you hold and speak with Vitus Azim. He's Executive Director of Ghana Integrity Initiative. Good evening, Vitus.
Good evening. I'm sorry, the line is very faint. I'm not hearing you.
I may have to speak a bit louder. I'm just welcoming you on today's big story.
You probably need to call again.
Hello, Mr. Azim. Okay, we'll be trying to reach him again to continue with the conversation. But Malik, you were talking about...
Yes, so I'm saying that that's how the law works.
Okay.
Everybody has a right to challenge any allegation made against them.
So what should we expect from now as media house? I mean, being aware of the fact that some media houses have also been sued, and we don't want to be contentious. So what should we expect?
Well, at this point, he's making a specific demand.
Right.
He's asked that transcripts of whatever he's alleged to have done should not be put out there. The persons who have gone ahead to go and do that after he issued the writ in court, and you heard Frank David eloquently speak to this, that once a case is in court, the matter in issue, you should not be seen to be doing anything that indicates that you are holding the court in contempt.
Right.
Because going ahead to go and publish a matter, when somebody is in court, asking that court to stop you from publishing that matter is disrespectful of the court. What he's seeking in this third application he has brought before the court is for those media houses to be cited for contempt.
Okay.
Because he's asked that this should not be published, and you are going ahead to go and publish it.
Okay.
What the media will do henceforth is to watch. Remember that he's just one of he and Justice Muhammad Habib Logo are the only two people who have gone to court on this matter. So we are at liberty to do stories on the other cases, but these ones, if we were to receive another transcript from Tiger PI or some other person, we should be careful not to publish it. Otherwise, you may just be incurring the anger of the court.
Well, many thanks to you, Malik Dabo. Well explained, and I think you've made your point, and so we have to be careful. I mean, that's what it all means. We've been trying to reach Vitus Azim to speak on this matter, but we're having problems with our phone lines. But basically, we've been talking about the 15 people who have been indicted in the recent bribery expose within the judiciary, and then we're told that some of them have been identified as officers of the police service, the prison service, and the Attorney General's department. We'll be looking at the implications of the two cases that have come out from the main case and whether or not the screening should go on. We'll bring you more on our subsequent bulletins. This is today's big story. My name is Aisha Bribery.